One Supreme Court case could decide the future of the Second Amendment itself. A single ruling that might redraw the invisible borders of your freedom. From the grocery store, to the church parking lot, to the sidewalk outside your own home. This isn't just another legal fight, it's a collision course between liberty and control, and the verdict could change where you can carry a firearm forever. Right now, the U.S. Supreme Court has agreed to hear a case born in Hawaii. A law so restrictive that it assumes you're forbidden to carry unless someone gives you permission. And if the justices strike it down, that one decision could send shockwaves through every state, every business, every so-called gun-free zone in America. So ask yourself, when the highest court in the land draws the line, will it fall on the side of freedom or fear? Because this is more than a case, it's a reckoning. Welcome to the Firearms Legal Desk, where we break down the rulings that define your rights, your safety, and your future. Subscribe now, and stay with us, because when this verdict drops, you'll want to be the first to know how it changes everything. Part 1. Freedom versus restriction. What counts as a carry zone, and who gets to draw the lines of your freedom? Imagine this: you've passed every background check. You've trained. You've earned your concealed carry permit. You walk into a coffee shop after work, and without a single word spoken, the law already assumes you're in the wrong. Not because you broke a rule, but because the state decided your right to defend yourself stops at an invisible line painted on private property. That's the heart of the fight now before the Supreme Court, ruling that could determine whether your freedom to carry ends at the front door, or extends everywhere your feet can lawfully stand. Because in Hawaii, and in states watching closely, you are guilty of carrying until proven invited. It's called the vampire rule. Just like the legend, you can't enter unless you're invited. Under Hawaii's carry law, even licensed gun owners must get explicit permission before stepping onto most private properties with a firearm. In other words, your permit means nothing unless someone else says yes. Advocates for gun rights call it one of the most sweeping infringements in modern America. Supporters call it common sense. But deep down, everyone knows what's at stake. If Hawaii can flip the default from freedom to restriction, so can any other state. And the dominoes could fall fast. To the challengers, this is simple. A right that needs permission is not a right, it's a privilege. They point to New York State Rifle and Pistol Association versus Bruen, the 2022 case that blew the doors open on public carry. In Bruen, the court declared that the Second Amendment protects an individual's right to carry firearms in public for self-defense. And any restriction must fit with America's historical tradition. There was no vampire rule, in 1791 no nationwide presumption that you're forbidden from carrying on common ground. History, they argue, stands squarely with the citizen, not the state. To them, Hawaii's law isn't about safety, it's about power. About who decides when your right begins and ends. Hawaii defends the law with a different kind of conviction. They say property rights matter. They say gun owners are still free to carry, they just need consent. Officials warn that if every business, bar, or hotel becomes a place of open carry, ordinary citizens could feel trapped between fear and uncertainty. They claim the rule protects peace, the island's unique culture of safety, the spirit of aloha. To them, the law doesn't take rights away, it balances them. Your right to carry ends, they argue, where another person's right to control their property begins. But for millions of lawful gun owners watching from the mainland, that balance sounds dangerously close to surrender. Across America, the ripple is already spreading. If Hawaii's law survives, other states may clone it. If it falls, entire networks of gun-free zones could collapse overnight. One ruling could decide whether your everyday stops, your gas station, your grocery store, your child's daycare, are considered off-limits forever. It's not just about carrying a weapon, it's about carrying responsibility. And about a government deciding if that responsibility can exist in public at all. The question echoing through the court isn't technical. It's moral. Does the state have the right to assume you're a danger until proven otherwise? Because if the answer is yes, then the Second Amendment isn't the only thing under review. The very definition of freedom is. And when the Supreme Court takes its seat, the fight won't just be about Hawaii's law, it will be about the Constitution itself. Because this next round isn't fought with bullets or ballots. It's fought with history, precedent, and 9 voices behind one bench. Part 2. The Legal Showdown. Behind the marble pillars of the Supreme Court, silence carries weight. Every echo, every word, becomes part of history. And in that silence, a question waits to be answered. Can the government decide where your freedom stops? The Hawaii carry case, Wolford versus Lopez, has now reached the highest court in the land. 9 justices, each holding power over how you live, how you defend, and how you walk the streets of your own country. No gunfire. No protests. Just arguments, calm, surgical, and capable of rewriting American law in a single breath. Because this time, the fight isn't on the streets, it's in the courtroom, where words are weapons, and history is ammunition. 2 years ago, the Supreme Court delivered a decision that shook the foundation of gun law in America. New York State Rifle and Pistol Association versus Bruen. That ruling said one thing loud and clear. If the government wants to restrict the Second Amendment, it must prove that similar restrictions existed in American history. No history. No restriction. Bruen was the earthquake. But Wolford versus Lopez could be the aftershock that changes the map of modern carry rights forever. Because after Bruen, states like Hawaii tried to adapt, creating new laws that look constitutional on paper, but restrictive in practice. And now, that workaround stands trial. If Bruen opened the door to freedom, Hawaii is testing how far the government can push it shut again. Hawaii steps into court not as a villain, but as a believer in control. Their lawyers will argue that the vampire rule is about protecting people, not punishing gun owners. They'll say, property owners have rights too. Private business is not public domain, and states should be able to decide how far those rights go. They'll remind the court that every right, speech, religion, privacy, has limits. And that without limits, freedom turns into chaos. Their tone will be calm, confident. But underneath, they know, if they lose, the ripple will be massive, not just for Hawaii, but for every blue state that followed its lead. Because if Hawaii's rule falls, California, New York, New Jersey, all of them may have to rewrite their gun laws overnight. On the other side stand the challengers, ordinary citizens backed by gun rights advocates and constitutional scholars. Their message is as sharp as it is simple. The Constitution doesn't ask permission. They'll argue that the right to bear arms is already the default, not an exception. And that Hawaii's law flips that truth on its head. They'll bring out history, old American laws that allowed open or concealed carry in everyday life. They'll bring out logic, that property owners can still ban firearms voluntarily, without the state assuming everyone is forbidden. And they'll bring out emotion, stories of citizens left defenseless because permission was impossible to obtain. Their goal isn't just to win this case, it's to force the court to draw a bright, unbreakable line around the Second Amendment. One that no state can bend again. Inside that courtroom, history and fear will collide. The conservative justices, Thomas, Alito, Gorsuch, may look to the founders' intent. The liberal justices, Kagan, Sotomayor, Jackson, will question how 18th century rules fit into a 21st century society. Chief Justice Roberts and Justice Kavanaugh may seek middle ground, a ruling narrow in scope, but wide in effect. The air will feel heavy, every question laced with consequence. What counts as a sensitive place? Do states have the right to preemptively say no? Where does property law end and constitutional law begin? Each answer will ripple through time, shaping not just Hawaii's law, but every gun regulation yet to come. And when the gavel falls, one side's vision of America will break. This case isn't about carrying on a beach in Honolulu, it's about the philosophy of power. Should freedom be the starting point, or the exception? Should government presume you're trustworthy, or dangerous? Should your right depend on someone else's comfort? These are the silent questions behind Wolford versus Lopez. Because if the court sides with Hawaii, the vampire rule becomes a model for every state that wants to cage public carry in new ways. But if it strikes it down, the tide will turn. And the idea of gun-free zones, as we know them, could collapse overnight. In a few months, the Supreme Court will issue its decision. 9 signatures, hundreds of pages, and one irreversible verdict. But make no mistake, this isn't just a legal ruling, that it's a cultural earthquake. Because if the court declares that the right to carry extends by default, America will wake up to a new reality. One where permission is no longer the gatekeeper of protection. And if it goes the other way, we may see the most restrictive wave of carry laws since the 20th century. Either way, the decision will carve itself into the future of the Second Amendment. The justices will soon decide, not just what the law says, but what liberty means. And when that ruling drops, it won't just change policy, it will change how you live, where you go, and how you defend what matters most. Part 3. The real-world consequences. When the gavel falls, the streets will feel it. The morning after the verdict. The ruling drops on a quiet morning, and no sirens. No fireworks. Just one headline that tears across every screen in America. Supreme Court expands right to carry. And instantly, the world changes. Gun owners cheer. Governors call emergency meetings. Police chiefs scramble to rewrite protocols. In some states, signs come down overnight. Gun-free zone stickers peeled off windows, replaced by confusion and debate. Because for millions, this isn't theory anymore. It's reality. And the question echoes from coast to coast. Did freedom just expand? Or did safety just shrink? Within weeks, the nation divides into two Americas, not by geography, but by interpretation. In red states, lawmakers celebrate. They pass resolutions reaffirming citizens' rights to carry nearly anywhere, from public parks to private lots. Training programs and firearm safety courses fill up overnight. Gun ranges become community hubs. In blue states, panic brews. Governors call the ruling a dangerous overreach. Cities rush to declare new, sensitive places, from subways to hospitals to parks, hoping to salvage control. Lawsuits fly faster than ever before. The courtroom war didn't end, it just moved to every state capital in America. For police, the new reality is chaos wrapped in uncertainty. Officers on patrol can no longer assume who's legally armed. Traffic stops feel different. Knock on a car window could turn into a tense standoff, not from hostility, but hesitation. In some departments, morale drops. Officers whisper that the court's ruling has handcuffed their instincts. They fear hesitation will cost lives. Others welcome the change, saying it finally aligns law with liberty, that law-abiding citizens carrying firearms aren't the problem, but the deterrent. But either way, the line between protector and protected just blurred forever. The court's ruling didn't define every detail. T gave freedom, but left gaps wide enough for new battles to crawl through. Now, every state scrambles to redefine what sensitive places really means. Is a church a sacred space, or a public one? Is a university an educational zone, or a constitutional exception? Is a shopping mall a private property, or a public forum? Courts flood with new cases. Some judges strike down local bans. Others uphold them. The map of America becomes a patchwork of permission and prohibition, changing from county to county, city to city. And no one, not even the experts, can say exactly where you're allowed to carry anymore. Outside the courts, a deeper battle begins. Not legal, but cultural. Media outlets frame the ruling as a triumph for gun rights, or a ticking time bomb. Civil rights groups and police unions split. Business owners post new signs, no firearms allowed beyond this point. In one town, a mother posts a sign on her store door. I believe in freedom, but not fear. Please leave your weapons outside. Across the street, her neighbor puts up another sign. Freedom walks through this door armed. Two stores. One street point, two Americas, living side by side, staring at each other through glass. The Second Amendment isn't just dividing lawmakers anymore. It's dividing neighbors. The what-if ripple alternate futures. Scenario 1. If the court strikes down Hawaii's ban, the U.S. enters a new age of constitutional carry. Permit systems fade away. Gun ownership becomes a civil norm, not a regulated exception. Criminals hesitate more, unsure who might be armed. Insurance companies and businesses adapt, some even offering discounts for firearm training. But with newfound freedom comes growing pains. Accidental discharges rise in cities. Police misidentifications increase. And the debate intensifies. Was this liberation or overcorrection? Scenario 2. If the court upholds Hawaii's ban, the ruling reignites state control. Dozens of legislatures move fast, crafting tighter, sensitive place definitions to box and carry rights. Gun rights groups flood courts with new lawsuits, arguing the court betrayed Bruen's legacy. The tension doesn't cool, it explodes. Either way, the decision doesn't end the debate, it lights a new fuse under it. The global shockwave. The world is watching. Foreign nations take note. In Europe, commentators say America has lost control. In parts of Asia and Africa, leaders cite the ruling to justify tighter control, or looser freedom, in their own borders. Gun policy becomes not just national, but geopolitical. And through it all, the U.S. remains divided. One country, two philosophies, both claiming to defend the same Constitution. Because every time America debates the Second Amendment, the whole world watches to see which side freedom stands on. Beyond the headlines and politics, there are people. A single mother in Ohio who finally feels safe closing her shop at night. Young man in Los Angeles who's pulled over and wrongly detained because his firearm looked suspicious. A church in Texas that stops a shooting because a member carried legally to a child in New Jersey who finds a gun in a car and pulls the trigger by mistake. Each story, tragic or triumphant, becomes another page in the legacy of Wolford versus Lopez. The ruling may be written in law books, but its consequences will be written in lives. The final question: what does freedom really cost? As the nation adjusts to this new reality, one truth becomes clear. Freedom isn't free, it's fragile. And once expanded or restricted, it's rarely undone. So as America stands at this crossroads, we face the same question the founders did centuries ago. Do we trust the people with liberty? Or do we trust the government with control? Because no matter which side you're on, one thing is certain. When the Supreme Court rules, the country will never be the same again. This is more than a case, it's a test of who we are. And when the decision comes, history won't whisper, it will thunder. You're watching the Firearms Legal Desk, where law, liberty, and truth meet. Subscribe now, stay alert, and never forget: your rights only exist if you understand them.